Greetings and welcome back to this part 2 of our 3-part series going beneath the veneer of so-called gun control. In our first video, we got to explain that oftentimes political stories come at us so fast that it becomes an us versus them battle, and we never get the opportunity to really get some intellectual ammunition to take with us to actually understand the principles underlying something. And that's what this series is all about. So here in part 2, let's move beyond some of the rhetoric and statistical legerdemain that some of the so-called gun controllers would like to use out there, and let's dig down into what the Constitution actually says. Let's find out what the Founding Fathers thought about the Second Amendment. Hi folks, I'm Gardner Goldsmith for MRC-TV, and you know, many pushers of this wonderfully deceptive and dangerous euphemism called gun control often don't even bother to try to amend the United States Constitution to make it say what they would like to allow the government to do. Instead, they just read into the United States Constitution anything they desire. So why should the Founding Fathers have bothered writing it in the first place? Why bother putting an amendment process into it? Well, let's look at the actual wording of the Constitution that seems to be so problematic for the gun controllers out there and find out what the Founding Fathers really thought. The Second Amendment reads, quote, "A well-regulated militia being necessary to the security of a free state, the right to keep and bear arms shall not be infringed," end quote. And of course, the action part of the Second Amendment comes in the second clause. The second clause strictly prohibits any government, the federal government, any state governments, local or county governments, from infringing in any way on the individual right to keep and bear arms, to buy, sell arms, ammunition, anything like that. Verboten, hands off. And of course, this principle is ancient. The recognition of the principle goes all the way back to Aristotle, over 300 years before Christ. Aristotle actually said, quote, "Those who possess and can wield arms are in a position to decide whether the Constitution is to continue or not," end quote. Now, Aristotle understood that despotism came at the hands of the armed state when the civilian population was disarmed. Indeed, even the Roman statesman Cicero said, quote, "There exists a law inborn in our hearts that if our lives are endangered by plots or violence or armed robberies, any and every method of protecting ourselves is morally right," end quote. And what did the founders themselves had to say? Well, let's turn to one of them, James Madison. James Madison noted, quote, "The advantage of being armed, which the Americans possess over the people of most every other nation, forms a barrier against the enterprise of ambition. Kingdoms of Europe are afraid to trust the people with arms," end quote. Of course, Patrick Henry in 1788 stated at the Virginia Convention a very simple and very powerful sentence. Quote, "The great object is that every man be armed," end quote. And George Mason wrote this, quote, "To disarm people is the best and most effectual way to enslave them," end quote. The actions of the British government at Lexington and Concord during the Revolutionary era reflect just how important it was for the despots to try to seize arms. We all know what the Brits were trying to do. Indeed, century after century of human history has shown that to disarm the citizens is the first step towards destroying their lives and taking their property. It's happened from Lenin to Stalin to Hitler to Mao, all over the world. Despots first disarmed the citizenry. So the lesson's clear about firearms. The principle of self-defense through the use of a firearm was supposed to be protected by the Second Amendment, not infringed upon by agents of that very government. But what of the second weak argument that some of the gun grabbers might employ? The idea that the first clause of the Second Amendment refers to a militia. which is known in their eyes today as the National Guard. Well, it's very clear if we don't just listen to Patrick Henry, who said the object was that every man be armed. All we have to do is look at things like Antonin Scalia's Supreme Court decision in the 2007 Heller case. And in that, Mr. Scalia explicitly said that by looking at contemporaneous accounts of the founders, it was understood to be an individual right, not a group right.
Look, what the Constitution does, those provisions especially that guarantee individual rights, it takes certain matters out of the background rule of democracy, which is the majority rules. Now, there are exceptions to that, and most of them are in the Bill of Rights. The majority won't rule about speech, about religion, about quartering troops in homes, and so forth. Every one of those things is taken out of democratic self-government, and whenever you leave it up to the courts to read in a new exception, you're leaving it up to the courts to limit the scope of self-government.
And all we have to do is use simple logic. There's no such thing as a right for a group because groups are composed of individuals, and rights are only associated with individuals. We don't need to do anything else. Of course, we need to watch out for our rights because, in fact, even though many people applauded Justice Scalia's decision in that 2007 Heller case, unfortunately, at the very end of it, Justice Scalia wrote something that actually puts our rights at risk. And in part 3 of this series, we'll tell you about that mistake and why it's so important. And we'll also look at some of the logical arguments for and against the gun grabbers. So, thank you very much for watching. Don't forget to like and subscribe. And don't forget, if you're watching on YouTube, to hit the little bell, because that will tell you when new videos have popped up from MRC-TV. For MRC-TV, I'm Gardner Goldsmith.